So let's talk about assault family member cases. How do they get handled in Texas, specifically in Houston, but all over the state of Texas? This should be generally applicable. We're going to go over definitions and types of assault family member charges in Texas. All the assault charges that we're going to have in Texas are under Chapter 22 of the Penal Code. There is regular assault and there is assault family member cases. There's also aggravated assault, but it's all under Chapter 22, okay? There is technically not a separate statute for an assault family member case. All that happens when an assault family member case is charged is that a regular assault has been pled in the charging documents, like an information or an indictment. And then once they put that element down, once they write out that you're being charged with a regular assault, then the court makes an affirmative finding of assault having been done against a family member, somebody who you've been in a dating relationship with, or somebody that you lived with. So, yes, even college dorm mates could have an assault family member case filed on each other. So, that's the differentiation there between assault and assault family member. The biggest difference between the two is that assault family member cases enhance and they cannot be non-disclosed. They can't ever be expunged. So if you get, like, let's say a deferred probation for a regular assault case, a guy makes you mad at a bar, let's say, it's an Aggie and a Longhorn fighting, and there's a assault between the two, something like that, and you get charged with assault. You don't know that person, you're not family. So that's just a regular assault. That can be expunged from your record if it's dismissed. If it's not dismissed, then you can get maybe deferred probation. It ends without a conviction, but police can still see the deferred, and then you could get that non-disclosed, meaning sealed from public view. You cannot get a non-disclosure for an assault family member case. So if it has that affirmative finding, you can't get that. Another problem is that you're going to get what's basically a firearms ban for 5 years. You cannot possess a firearm for 5 years after having an assault family member conviction. That's under Texas law. Under the federal law, you can't never again can you possess a firearm according to federal law. But those get very rarely prosecuted. I've never seen them just in isolation find somebody at their home and prosecute them after 5 years. So, and the state prosecutors don't report that stuff to the feds. They're not going to mess with that anyway, unless you got 5 kilos of cocaine at home too. So let's talk about common scenarios leading to assault family member charges. Sad enough to say, anytime there's a holiday, there's an increase in these. During the pandemic, there was an increase in assault family member charges. So anytime family gets together, especially family doesn't have to live with each other every day, there's a potential for this. We get these filed. We get calls around the holidays a lot. Kind of sad, I know, but it's true. And that's not just true because people are committing family violence. It's true also because it's being reported when it's not actually being committed. People get mad and will sometimes report a family violence incident even when they very much later regret doing that. Family violence is the number one case to have the victim change their mind about wanting to prosecute. So we talked a little bit about the consequences of a conviction, meaning like you can't get a non-disclosure. It can enhance to a higher level offense. We're going to talk about that and then what those higher level offenses are. So the first level of a family violence case is Class A misdemeanor. That's up to 1 year in jail, up to a $4,000 fine, and probation for up to 2 years. So that is the lowest range. Technically, there's a Class C family member assault that you could have. That's only a $500 fine. It's a ticket. It is still a serious case, and you can still get enhanced for future offenses because of that. But just for purposes of this, we're talking about cases that get filed in the county court or higher. So third degree felony. Let's talk about assault family member third degree felony. Most of the time, this is because there's been either a strangulation that can make a very first offense a third degree felony if there's strangulation involved, or if it's a prior conviction or prior deferred probation, even on a Class C, and you get a new case that involves bodily injury against a family member, that's going to be up to a third degree. If you have two incidences of bodily injury within a 12-month period, that is going to be a third degree. For second degree felonies, if you use a weapon, a deadly weapon, that's going to be called aggravated assault family member. If you have a prior conviction for assault family member or a prior deferred for assault family member, and then you get arrested for strangulation family member, that's going to get up to a second degree. And then finally, for a first degree felony, the only way we're going to get there for a family violence case that doesn't have any punishment enhancements is going to be aggravated assault with a deadly weapon, family violence causing serious bodily injury. So if you got all of that, then it's going to be a first degree felony. Protective orders and bond conditions. Protective orders are an order from the court. Normally, these are called a MOEP, or Magistrate's Order of Emergency Protection, or an EPO, an Emergency Protective Order. In criminal law, these can be granted without a hearing, and they will be told to the defendant after an arrest. Most of the time, what they're going to say is for 61 days, you can't go home, you can't have any contact with the complaining witness. Sometimes they'll just say you can't have any offensive contact, which means you could go see a movie together, but you still can't go back to your house. Or they may last 91 days if there's an aggravated assault family member. So if it involves a deadly weapon, mandatory to go to 91 days. Bond conditions will do just about exactly the same thing. In Harris County, they'll call them a no contact order, but just as easily you could call it a bond condition imposing no contact with the complaining witness. That means you can't talk to the person alleged as the victim. This means you can't talk to your wife, you can't talk to your kids. If you're a male that's been charged with it, opposite way, you can't talk to your husband, can't talk to your kids, their brothers and sisters. It says normally just any family member, you can't have any contact. The problem with bond conditions is they last the entire case unless the judge changes them at the request of your attorney. And again, only the judge can amend the bond conditions. Let's say your wife calls 911. She says you slapped her in the face. It caused pain, no mark. You're going to get arrested for a Class A misdemeanor, assault family member. And these protective orders and bond conditions are going to apply. And then if she says the next day, I was making that up, I was mad, I'd had some alcohol to drink that night. He reminded me of a time that, I was cheated on, and I tried to get him in trouble. I'm sorry. These are still going to apply until we can get your case looked at by a prosecutor, evaluated, and then eventually dismissed. Sometimes the judge will come in and change these things, and we will have bond hearings regularly on these cases, normally pretty quickly. It is an emergency when you get arrested for family violence. It can be a life-changing experience. Pretty much every time it's a life-changing experience. So if you're watching this, it's probably not a good reason that you're watching this, and I'm sorry about that, but help is on the way. Talk to an attorney, and they can work on getting these things changed. So how do you build a strong defense for an assault family member case in Texas? First, you want to gather evidence and witness statements. If you have injuries to yourself, let's say you're the defendant, you were injured, and it was because you were defending yourself, the other person attacked you as well, then we need to take photos of that. You need to go see a doctor, get it documented that you've sought medical treatment. If bruises have come up at the beginning of the day of the arrest, but they weren't visible to police on scene because they were fresh, then a couple days later they're going to be turning darker, and then a few days after that they're going to get the iron in your blood is going to leave like a brownish yellowish hue. You want to get photos of all that stuff. I would say letters of recommendation are important to show that you're not just somebody who flies off the handle all the time. You want to explore a self-defense possibility with your attorney. And then again, you want to get an attorney. These cases are very difficult. They have severe, long-lasting ramifications. I've never seen somebody go into court on their own, ask the judge to remove the conditions of bond or protective order, and have it granted. I've never seen somebody represent themselves adequately to get those things changed. So if this kind of a case has popped up in your life, you definitely want to talk to an attorney sooner rather than later. And that is going to do it for today's video. If you like what you saw, click the like button, subscribe, do all the good stuff, and we'll see you next time.